New York State today filed what was called the most comprehensive lawsuit yet against opioid manufacturers, distributors, and members of the Sackler family. The Sacklers are the founding family that owns Purdue Pharma, which manufactures OxyContin, an opioid sold and abused throughout the crisis. More than 400,000 people have died in the past 2 decades from overdoses involving legal and illegal opioids, according to the federal government. At least 36 states and more than 1,500 cities and counties are also taking opioid manufacturers to court. Purdue Pharma is directly in the bullseye because OxyContin was so widely used and its marketing practices have been blamed. As William Brangham explains, the latest lawsuit comes as Purdue Pharma considers filing for bankruptcy.
The concern is that if Purdue Pharma does file for bankruptcy, the ability of all those states and cities to recover damages will be greatly delayed and reduced by perhaps billions of dollars. In filing her state's lawsuit today, New York Attorney General Letitia James seemed to target that very issue. The suit itself explicitly seeks to claw back money from members of the Sackler family, alleging they fraudulently transferred profits from Purdue to themselves.
This lawsuit contains detailed allegations about the Sackler family and their attempts to hide the vast fortunes they collected at the expense of actual lives. In an attempt to shield these fortunes from families whose loved ones have been killed by their products, we allege that the family has illicitly transferred funds from Purdue to personal trust so that they are potentially outside of the reach of law enforcement and our efforts to seek restitution or penalties.
In a separate development earlier this week, Purdue and the Sacklers settled with the state of Oklahoma for $270 million, just months ahead of what would have been a televised trial where that state took Purdue to court. Barry Meyer has been following all of this very closely. He wrote a book about Purdue Pharma called Painkiller, an Empire of Deceit and the Origin of America's Opioid Epidemic. Barry, welcome back to the NewsHour. Let's start talking first off about this New York case. The Attorney General in New York is arguing that members of the Sackler family somehow siphoned off profits from Purdue, stashed them away, and that constitutes fraud, the way they did it. Explain her argument.
William, this is all part of a legal chess game that's going on around the bankruptcy issue. First, Purdue laid down a marker by saying, well, we're getting sued by so many people, we may have to seek bankruptcy, and thus everyone suing us is going to be left out in the cold. That spurred the Attorney General in Oklahoma to strike a quick settlement with them. And now New York is coming in and saying, wait a minute, not so fast. We're going to stake a claim that the Sackler family has been siphoning off money. So if you try to file for bankruptcy, we're going to go after them and claw back this money for restitution.
So the argument in that case is that if you know your company is facing this avalanche of lawsuits and it might go bankrupt, you're not allowed to siphon money off from that company.
Yeah, there's a general concept called, I believe, fraudulent conveyance. I'm not a lawyer, but if you're like facing an avalanche of litigation and you say, you know, Cousin Joe, take $100 million and stick it in the Bahamas somewhere, that doesn't really help you at the end of the day if it comes out that you did that.
We should say here that Purdue vigorously denies New York's charges, called them baseless. The Sackler family also called this suit a misguided attempt to place blame where it does not belong. But the New York Attorney General's case really does target the Sackler family also for their behavior with regards to the management at Purdue and how the drug was manufactured and how it was marketed. What are they arguing in that regard?
You know, what we're seeing in all these lawsuits, and the New York Attorney General kind of went another step further, is the claim that the Sackler family was intimately involved in the operation of Purdue, that they directed some of the illegal marketing activities of Purdue or knew about them and benefited from them. Obviously, the family absolutely denies that. They said, we didn't know anything wrong was going on, and we moved quickly to stop it. But the the litigation is pulling up documents that are raising questions about that, and ultimately we will find out, hopefully one way or another, just what they knew and when they knew it.
With regards to the Oklahoma settlement, $250 million, you seem to be arguing that Oklahoma looked at this potential looming bankruptcy and said, let's just try to get what we can now before the company goes Chapter 11. Is that accurate?
Yeah, absolutely. I think the Attorney General of that state made it very clear in his comments that they were prompted by Purdue, this specter that Purdue raised of filing for bankruptcy. In fact, two of the Purdue family members were slated to be deposed in New York City about a week ago. Those depositions were put off, and lo and behold, the settlement sort of materialized quickly after that. And I think he was quite clear that, yes, they could have won a lot more money potentially if they went to trial, but they went on the bird in the hand type theory.
Barry Meier, as always, thank you very much.
It's a real pleasure, William. Thank you.